Hello and welcome to Listen and Score. As you all know, this channel is meant to read for you. If you have not yet subscribed, please subscribe, share with your friends. So, when you listen to the questions and answers, it will serve as a revision to you and a recollection, and a repeated listening makes you perfect with that. Again, we want to confirm that we are reading only from the material or the information which is available with us. You can cross check with the knowledge that you have and also the information that you have already in your hand. So, this is only to help you listen and recollect and score more marks. All the best in your examinations. In this particular video, we are going to see about theory of separation of powers, position in India, UK and USA. This question comes under administrative law, third semester, unit 2. So here we go with it. Meaning, in the olden days, the king was supreme. He was having all powers, viz. Legislative, judicial and executive. All these powers were vested in one person. It was a past thing. The establishment of democratic countries is a new trend. The principle of democracy is explained by Abraham Lincoln as the democracy is for the people, by the people, and to the people. In the place of the police state, the welfare state has occupied. In this welfare state, the governmental system is also reorganized. The government has three separate wings. Number 1, legislature. Number 2, judiciary. And number 3, executive. In almost all the democratic countries, these three separate functionaries are working separately. The legislature, that is parliament, legislates statutes. The court, that is the Supreme Court and its subordinate courts, administer the justice. The executive, all governmental departments, ministers, etc., administer the administrative affairs. The parliament will not interfere in the matters of the courts and the administrators. The courts will not interfere in the matters of legislature and administrators. The executive will not interfere in the matters of legislative and judiciary. There is a triangular relationship in between these three machineries. This is called as the doctrine of separation of powers. Example, for the doctrine of separation of powers, the USA is the best example. This doctrine has been developed in America to the highest mark. In America, the Congress has legislative powers, President has the executive powers, and the Supreme Court and its subordinate courts have the judicial powers. There is a coordination between these three most important wings of the state. In fact, the rule of law in England hampered the recognition and growth of administrative law, whereas the separation of powers in America has given an intimate impact on the growth of administrative law. Leaders of this theory, Plato, in his book Republic, first enunciated the doctrine of separation of powers for the best ruling of a state. His student Aristotle wrote book Polities. Both of them were the Greek political teachers and philosophers who were in the 4th and 3rd centuries BC respectively. In the days of Plato and Aristotle, it was difficult to imagine about this theory and its function. In those days, there were small kingdoms. Of course, there were some small democratic countries too, which were too in preliminary stages. At that time, all three functions were centralized in one unit, say whether they were kingdoms or democratic countries. After them, Baudin, the French philosopher, and Locke, the British political scientist, explained this theory in the 16th and 17th centuries, respectively. It was Montesquieu who analyzed the separation of powers systematically and scientifically. He wrote Esprit des Lois, the spirit of the laws, in his book. He most clearly explained this theory and its necessity for implementation. He lived in the 18th century. He was a French philosopher. Now let us see the principle underlying in the doctrine. If you see the principle, it goes like this: executive plus judicial plus legislature is equal to monarch, autocrat, tyranny, corruption. Lord Action explains every power tends to corrupt and absolute power tends to corrupt absolutely. Where these three powers are vested in one person, he becomes tyranny, autocrat, and monarch. It results abundant powers centralized in one person. People will suffer with very worst conditions. They could not live happily. The history proved it. Examples: Louis XIV in France, Idi Amin in Uganda, Saddam Hussein in Iraq, Musharraf and other leaders of Pakistan, Mubarak in Egypt, Gaddafi in Libya, military junta in Myanmar, Taliban's in Kabul, etc. Madison explains the accumulation of all powers, legislative, executive, and judicial, in the same hands, whether of one, a few, or many, and whether hereditary, self appointed, or elective, may justly be pronounced the very definition of tyranny. Jain and Jain writes, the doctrine of separation of powers has influenced and has itself been influenced by the growth of administrative law. All the jurisprudence and jurists unanimously opine that the government should not function on the will and whims of the officials. They also opine that the judiciary must be independent from the other branches. Now let's see about the doctrine of separation in USA. The framers of the Constitution of USA imported the doctrine of separation of powers in framing their constitution, which was drafted and came into force with effect from 1789. The legislative powers are vested in the Congress. The executive powers are vested in the President. Judicial powers are vested in the Supreme Court of America and its subordinate courts. Thus, the American Constitution is the classic example of the doctrine of separation of powers. Article 1 of USA Constitution says, all legislative powers herein granted shall be vested in a Congress. Article 2 says the executive power shall be vested in a President. Article 3 says the judicial power shall be vested in one Supreme Court. The Supreme Court of America in Sattinger versus Philippine Islands, a 1928 case held, it may be stated as a general rule inherent in the American constitutional system that unless otherwise expressly provided or incidental to the powers conferred, the legislature cannot exercise either executive or judicial power. The executive cannot exercise either legislative or judicial power. The judiciary cannot exercise either executive or legislative power. The Nixon's Watergate case is another best example of separation of powers in America. In this world famous case, Nixon, the then American president, was found guilty by the Supreme Court of America. Clinton, the President of America, versus Monica sexual cases have become world famous in 1998 and 1999. The Administrative Procedure Act 1947 brought a great change in the administration of America. This act has given a new shape to the executive. It has also given an integrity and full-fledged branch of executive. Shards and the American jurisprudent wrote, American constitutional law, he writes, functions have been allowed to courts as to which Congress itself might have legislated. Matters have been withdrawn from courts and vested in the executive. Laws have been sustained which are contingent upon executive judgment on highly complicated facts. By this means, Congress has been able to move with freedom in modern fields of legislation with their great complexity and shifting facts, calling for technical knowledge and skill in administration. Enforcement of a rigid conception of separation of powers would make modern government impossible. Therefore, the doctrine of separation of powers had a great impact on the growth of administrative process in the United States. Coming to the doctrine of separation of powers in India. Like the American Constitution, our Constitution does not mention the clear provisions of separation of powers. Yet, by the perusal of articles and their arrangement, one could easily understand that the framers of our Constitution too inclined towards the doctrine of separation of powers. All the executive powers have been vested in President. All the legislative powers have been vested in Parliament and the state legislatures. Subject to the conditions laid down in Article 246 and 7th Schedule, all the judicial powers have been vested in the Supreme Court. The Constitution clearly demarcates spheres for each of the branches of the government, viz. Judiciary, executive and legislative. As Basu mentioned, each of these branches does not encroach the other branches in essential elements, but each of the branches may encroach the other branches in the matters of incidental elements. The history proves that after independence, India is one of the countries which favors doctrine of separation of powers. Raj Narayan versus Indira Gandhi case is the leading case and example. The Allahabad High Court criticized the then Prime Minister Srimati Indira Gandhi for the misappropriation of her power as the Prime Minister and quashed her election in Raebareli in the general elections 1977. Just like the Nixon's case in America, this case is also a leading case in the Indian constitutional history. Sri Subba Rao, the then Chief Justice of Supreme Court of India, while disposing the case Golak Nath versus State of Punjab, expressed, the Constitution brings into existence different constitutional entities, namely the Union, the states, and the Union territories. It creates three major instruments of power, namely the legislature, the executive, and the judiciary. It demarcates their jurisdiction minutely and expects them to exercise their respective powers without overstepping their limits. They should function within spheres allotted to them. In America, it is strictly and rigidly followed, whereas in India, its application is liberalized and flexible. Now let us see the last part of the question. That is the doctrine of separation in England. Okay, the doctrine of separation of powers, in fact, had not been accepted in England. The theory of integration of powers has been adopted in England. Convention has been playing a very important role there from the last several centuries to up to now. Conclusion. Jain and Jain writes, the doctrine of separation of powers has influenced and has itself been influenced by the growth of administrative law. The doctrine of separation of powers has a great impact on the development of administrative law in USA, Australia, India, and other democratic countries. It is a modern technique. In fact, the administrative law itself is a newborn child of the 20th century. The doctrine of separation of powers has nourished it so that it can become an integral and full grown person. In doing so, it also considerably succeeded. Yes, hope it is clear. And if any suggestions are there, please do mention in the comment section. And please subscribe and share with your friends. Thank you for listening.